That present from the board are, to my left, Jay Mancara, and to my right, Charles Dobbins, myself, Robert Early. Can I get a motion to waive the reading of the public minutes from the Board of Assessors meeting held on Thursday, August 1st?
We have a June 20th and an August 1st.
20th, right?
And August 1st.
Accept them and place them on file.
So moved. Second.
All those in favor say aye.
Aye.
Opposed, nay. The ayes have it. Can I get a motion to waive the reading of the non-public minutes from the Board of Assessors meeting held on Thursday, June 20th, accept them and place them on file?
So moved. Second.
All those in favor say aye.
Aye.
Opposed, no. The ayes have it. Next item is on the agenda is communications. Jessica?
I don't think we have anything. No,
Nothing?
we're good.
Okay. Old business, the board may or may not address. First is 45 Dogwood Drive. We discussed that back on June 20th. We've gotten some information. Is everybody up to date on that? But we can actually give an abatement for a prior year.
Oh, yeah, I sent that over, I thought.
So,
But that's actually right in the first line of the Section 7616, Title 5, that gives the board the authority. The selectmen or assessors, for good cause shown, may abate any tax, including prior year's taxes, assessed by them or by their predecessors, including any portion of interest accrued on such tax. That's in the first line of the...
okay. Can I get a motion then to approve the abatement for the property at 45 Dogwood Drive, Unit 203 for 2023, the Veterans Credit?
So moved. Second.
All those in favor say aye.
Aye.
Opposed, nay. The ayes have it. The Veterans Credit is approved. The next item is the commercial abatement that we discussed on June 20th for 41216 Marshall Street. We don't have really any new information. Go ahead.
Oh, no, this is the one, I think we were talking about, the actual being able to review the information that's provided with the filing for the abatement, the financials, where we had to go down in the basement to look at it. You know what I mean? When we're talking about
Right.
some of the commercial properties, I had asked, why do we have to go down and see it under the, cloak of darkness?
I mean, you asked back then if our job is basically just a rubber stamp, and it's not, but
Yeah.
it's not supervisory either, so.
Oh, exactly. And I'm not looking to supervise anyone. What I'm looking for is just to see what the evidence was presented by the taxpayer. And looking at the Public Records, Open Records Act, and that is actually an exception to that regarding abatement filings, that the information provided by a taxpayer become government records when they turn it in, and we have to keep it open. So the concept of having to go down and look at it downstairs in the assessor's office, not being able to have it presented with the request for the abatement, I think is kind of, it flies in the face of the Open Records Act. So I think that every time that a commercial taxpayer comes before us and presents their case, we should be able to see all the evidence being presented. I mean, I spoke to somebody at the Board of Land and Tax Appeals, and if it gets appealed up to them, it's open record.
So the recommendations we've received from the assessors we're working with, as provided in the packet here, state that you can discuss it in non-public session, which I've brought them here if you decide to do that. We can't do it in public, but you can look at it in non-public.
Okay.
Or you could come to the office individually and review any documents you wish to, ahead of time. Those were the two suggestions.
I'd like to know what authority their recommendation is based upon.
We've provided some here in the packet. I don't want to speak personally on it. I wasn't the one that provided the recommendation.
Yep. Who did?
Our contractors, Whitney Consulting.
Okay, so we should get from them
Right.
what their
Well, they've provided it
professional-
here.
Okay, where is it?
I believe There's an RSA A54, commercial or financial information is underlined within the paragraph. That's what was provided by Steve to us.
Yeah.
And then just by email without records, Steve had recommended either non-public or coming to the office, and Bob didn't have the RSA in front of him at the time, but he had recommended it should be treated as confidential, labeled as such when distributed to the board. It's okay to provide the data, but the discussion should occur in non-public.
Yeah, and I've seen this, and I see his two options here, and my question was, what authority is he using to justify those two options?
I'm not going to speak for him.
No, I understand, you
so-
don't have to, let me finish. And then if you flip back to later in his email, he cites RSA, or I think actually, Michelle, did you cite this one? No, well, you forwarded this one to me from Stephen. He cites RSA 91A5, Section 4.
Correct.
But that's the wrong section. That's responding specifically to internal personnel practices, and that's got nothing to do with this. And I think I sent you an email, Michelle, that showed what I think is the more appropriate statute, and it spoke directly to filing for abatements as well. Let me find that email.
Yeah, we received an email. It just was sort of looked like a copy and paste of
Of the
an
statute.
RSA statute. Wasn't really sure what it was
Yeah, that you, okay.
pertaining to, but I'm not a lawyer, so I'm
Sure.
not going to
So
speak on.
But I would like to see Steve
Yeah,
respond
unfortunately,
back.
they're unable to make the third Thursday of the month meeting, so we might be changing our meetings.
Okay, but we can do it via
but we
email
can
as
do-
well. Understanding that all of those communications are public documents, are open communications, so.
Yeah,
Yeah, it's the 91A3 non-public sessions, with the exception, where they discuss exceptions under paragraph 2. So I think that's more in line. And I think, it's very important that we maintain that we are in total compliance with the Open Records Act.
we can only discuss them in non-public or public, so these 3 pages are kind of lower.
No, I was going to say, perhaps we should put the question to the city's legal department.
Sure, I'm happy to answer that question. I mean, we're going to be going in a non-public for advice of counsel later. Perhaps we should table it till that time.
Okay.
Okay, but that doesn't solve our problem for answering this 2023 commercial abatement.
So could someone I know you just pointed at this, I'm
Yeah,
sorry, as
That's okay.
indicated, I hope by my staff, I had a childcare issue this morning. So what is the exact question?
So the question is, which RSA governs, and then I'll turn it over to you, because you're the one more.
Governs what?
Just discussion of financial documents and
Commercial
Provided by
abatement
the taxpayer.
applications.
It says Section 91A3,
Yep.
non-public sessions, paragraph 2, only the following matters shall be considered or acted upon in non-public session. And then if you go down to letter E, it says, any application filed for tax abatement pursuant to law with any body or board shall not constitute a threatened or filed litigation against any public body for the purposes of this subparagraph. So that means that when they file for an abatement, it's open records. It needs to, it should be made part of the record. And when they go up to Concord, if they have to file an appeal and they go up to Concord, it's open records.
But they
There are
haven't done
certain
that.
instances
Sure.
with information that is supplied with an abatement, either application at the municipal level or an abatement appeal, are filed under seal and are considered confidential. Rent rolls, et cetera. We also, rent rolls, we often see as marked confidential, and those have been treated confidential. So there's portions of the abatement and
Right.
portions of an appeal that are. If you're talking about going into non-public, I'm not aware of, I think the practice here in the city has been that they're discussed on advice of counsel, because we come in for abatement appeals, which are litigation, not the abatement. The appeal is distinct,
Yeah.
right? That's a different statutory section than the abatement to the municipality. So we're discussing actual litigation, and it is advice of counsel. So when we go into non-public to discuss that, it's under the advice of counsel, non-public.
Okay, but you were saying things like rent rolls. Well, obviously, rent rolls have personal information on it, so you would want to keep those non-public. But if something like a trailing 12 financial statement that doesn't have any personal information on it is included in the appeal, what authority are you using to say that that type of information is not public?
Okay, so again, I want to make sure, because you're citing the going in a non-public session, and that's different than what document is going to be considered exempt under 91A5. So are you discussing going into non-public session to discuss an abatement, which is 91A3? Or are you discussing what, if we have a document request, would be subject to disclosure under 91A4 and not subject to an exemption under 91A5? So is it document or a meeting that we're discussing?
We're talking about the evidence that they're presenting.
Documents and.
Okay, so
when and where
documents
they
at
can
the meeting?
review and discuss
Yeah.
income and expense forms or commercial abatement type of thing.
So if someone comes in and says, I want to present this case,
No, like if we're presenting for a recommendation of approval or denial, we don't generally bring the application to the public documents. It's not in the packet.
okay. I mean, you could,
They
with
could
the
go to
exception.
the office to read through it, or we could discuss it in non-public, was the advice we were giving. But he was wondering what authority are we saying that those income and expense type of forms on an abatement are not public? Why
Right.
aren't they public? And
Yeah, well,
where does it
here's my
say?
issue.
And we did, and
Okay.
our consultant referred to the A5, saying that they were more for non-public
Okay, so,
As-
counsel, what do you,
financial.
all right, so
So-
if you're talking about which documents would be considered confidential under 91A5, that's going to be, it's going to be the confidential, commercial financial. That's going to be subject to a balancing test, which the Supreme Court has now put in place. It's not in the legislative statute, right? It says it has to be balanced, and would disclosure be more, prejudicial or violate the confidentiality of the business more than, does that outweigh the public's, quote, right to know? I'm not aware right now, as I sit here, of a specific case on that. On the commercial financial, it's been the practice that, commercial businesses, as you know, up through the Supreme Court of the United States, are treated as individuals. They have confidentiality rights. There is an argument to be made. I'm not saying who would win this or not, by the way. Currently, the Supreme Court is extremely.
You're talking New Hampshire Supreme Court?
No, that's the U.S. Supreme Court. Remember the lobbying, maybe, I don't know, there was that lobbying that they are, corporations aren't people, so they have rights. That was the U.S. Supreme Court, and that thinking permeates down through all the state courts. So the corporation can have privacy rights. And the benefit to having accurate information, which you might want to keep commercially confidential to evaluate abatements and try to get at fair assessments, the argument would be outweighs the public's, quote, right to know the nitty-gritty financial information of various corporations and LLCs and even, private owners of rental properties within the city. That would be the argument. Would that win? I don't know right now. I think it would be worth going. I would recommend that we would actually do that. And frankly, I think the Council for all the corporations in the state would as well. There is also case law that says that, just because there's confidential information in a government's files, and for this we can extrapolate to Social Security numbers, health information, right? We get health information from folks, elderly exemption, we get a lot of their personal financial information, right? Same idea. Like, we want accurate information. We want to encourage this public policy to get public accurate information on these sensitive topics, but it doesn't mean it automatically becomes public information for everyone to know, just because you have to do it to pursue your due process rights under, for an exemption or for an abatement. I think, the abatement itself, most of the supporting documentation, I know sometimes they try to put confidential on an appraisal. I would say no, we'd have to go through and see if there's anything actually, if the appraisal itself had the actual rent rolls, we would probably compromise and do that, but a lot of it would be. We have gone to to support this too, in Pheasant Lane Mall, for example, the hearing was closed because we were talking so much about the individual malls' financial matters, just the rents, the this, the that, the bankruptcy, everything. And so not only were the paperwork all confidential, it was a closed hearing because we couldn't have the hearing without talking about that, so the whole hearing was closed. So there's protective orders that are put in place, for example, in the PSNH cases right now regarding certain information. So there is support for this, that certain information is going to be withheld from public so that we can have an honest and robust conversation around the matter.
In settlement-like issues.
I'm sorry?
In settlement issues.
In settlement, I'd say what I'm expanding is it's to both the application process to the municipality and in litigation.
Okay, but in those cases, I bet you had firm support as to why it needed to be a closed session, and you could actually cite a statute as to why that particular situation went behind closed doors. I'm just saying here, this is just a regular filing, and I'm trying to understand that if it gets up to Concord,
So an appeal.
and it becomes litigation, is that now public record? Is the evidence that's presented in that, to the board there, is that open for everyone's eyes to see because it's now evidence in a court case?
Yes, unless there's a protective order in place, and that's
Sure.
often the case.
Sure, okay, but the answer is yes, with exceptions.
Well, of course, that's where
Okay,
you
so
start
I'm
with.
trying to understand, what are the exceptions here?
Okay, so again, are you talking about the exception for producing or having open records is the one cited here, the commercial, financial, and information, as long as the balancing tests that it's more important that the privacy rights of the business outweigh the public's right to know. And I'd say there's a narrow, it's been our interpretation that there's a narrow alleyway for that. So that's what it is. So we've kind of, is there another question I can ask? Because that's the exemption that we relied upon for documents. As to going in a non-public session, it's a little, there's a disconnect between reasons to go in a non-public session and documents that you can exempt from disclosure. That's just a fact. And we come up against it, not only in this municipality, but in others, that yes, you've got a document that would clearly be exempt from disclosure, but it's part of but you need to discuss it. What do you do? And so sometimes that goes into the reputation one. If we're going to be talking about reputation of a business, for example, if we're going to talk about their business practices and, perhaps that their rents are too high or too low, or they're derelict in their maintenance, and that's why they're not getting, tenants and whatnot. So that would be something we could explore if that's where it was. But I think it's also going to be, we're talking all generalities, and what you are asking is always fact-specific.
Yep.
So if there's specific facts, specific applications in front of you that you would like an analysis done on, we can do that.
All right, well, then why don't we do this? During our non-public session, we take a look at that file, and we'll see exactly what's been presented and why it was kept out.
When was this? I guess I'm just not even sure of the context
June
here.
20th, we had 5 commercial abatements presented, and
We don't
2 were
have
tabled.
The information that you're talking about, though, right?
Well,
We don't have any financial information.
Well, I was supposed to, I think the email said that we had to take it downstairs. We had until August 10th to go down and review it. So you're saying there was nothing to review?
Oh, I haven't seen anything, so.
I know, because you were supposed to come in and see it. That's the point. So there is stuff downstairs that you,
There's stuff here that
Okay.
we can look at in non-public. I didn't look at it, it's whatever the applicant provided on their application,
All right.
which Vision
You
had
have
then
there?
recommended for, one was for approval, one was for denial, I think, based on lack of much information or something, and that's why you were asking, well, what information was submitted, and I don't know, I wasn't the one that looked at it, so.
Yeah.
We have it here if you want to look at it in non-public session.
Okay.
You can do that.
We'll look at those both of those in non-public. All right. New business items, exemptions and credits. Jessica? Veterans credits?
Okay, so we have some veterans credits here, recommended for approvals. I could just go through them briefly, let you know why they're being presented now, which is traditionally a little bit later. We have 6 Birch Hill. The applicant had been receiving the veterans credit, and then it was removed earlier in 2024 because they did not requalify in time, but they responded very quickly once they received that, and they provided all the necessary documentation to requalify. Staff recommends reinstating the credit. The applicant has provided a letter within the packet. And then I'll skip down to D, which is essentially the same situation. 5 Bartimus Trail, the veterans credit was removed in 2024 because they didn't requalify. After that was discovered by the applicant, they've since responded and supplied all of the necessary documentation to continue to qualify, and staff recommends reinstating that credit. They've also submitted a letter in the packet. And then B and C are of similar reasons. 4 Rodian Drive 107, the applicant moved from one home in Nashua to another, and they've requested the veterans credit be transferred from the previous home to the new home, which is allowed. And the applicant has been receiving the credit since 2019 and continues to meet the criteria. So we would be moving it to the new address. And C, 6 Great Stone is the same situation. They have been receiving the credit since 2004 and are moving from one home in Nashua to another and are requesting that the credit be moved to their new property. And so we recommend approval of those 2 for those reasons. And then the final one is an all veterans credit, A, for 4 Airlie Ave. This one we discovered after the spring votes that the applicant had applied on the same application, handles various different things that you can apply for. So on this application earlier this year, they applied for the veterans credit and the solar exemption from January of 2024, and the solar exemption was reviewed and approved and brought to the board for approval in the spring, but we realized afterwards that the staff had not reviewed the veterans portion of the application, and it had not been in the list to present to the board for approval. So staff has since reviewed the application and the supporting documents, and the applicant meets the criteria for the all veterans credit, and we recommend approval of this credit. So all in all, staff is requesting that and recommending that you approve the veterans credits per the list provided.
Any questions? Can I get a motion to approve the credits as presented?
So moved.
Second.
All those in favor say aye. Aye. Opposed, nay. The ayes have it.
Okay, next we have some religious, charitable, and educational exemptions that have come in this year. The first section is the religious exemptions. We have 3, 6 Harvard Street, 97 Farley Road, and 48 Palm Street. I visited and inspected these 3 properties earlier this summer and confirmed that they are owned, operated, and in use for their charitable purpose of their religious exemption.
Excuse me, Jessica,
Yep.
where is that?
It's in the new business section.
Okay.
After the credits and approvals, there's 2 letters, and then there's another cover page for new religious.
Got it.
Got it. All right. So we are recommending the 3 religious exemptions as they meet the standards. And then number 2, we have 3 charitable exemptions, 2 La France, 121 to 127 West Pearl, and 2 Shattuck. I inspected these 3 properties this summer. These are properties that were taken over by these charitable businesses, and they own, occupy, and are using those venues by the annual deadline and meet the criteria for 2024 to come online as exempt properties for the charitable reason. We have 2 charitable exemptions recommended for denial, and these are for the same reasons. So 151 Toll Street and 16 Broad Street. These are charitable organizations that have purchased these properties, but they have not occupied the space by the annual deadline, which is April 1st, for their charitable purposes. Toll Street, when I was there this summer, they were saying probably was going to be occupied by July 15th. And 16 Broad Street is currently under renovation with permit. They've received their zoning approval. They have permits out, and they're expecting to occupy the space in September. So they are both aware that they would not qualify for 2024, but they should reapply for 2025 and should meet that standard. So we recommend those 2 for denial. And the final one is an educational exemption for a school at 9 Townsend West, which Miles and I inspected this spring. They were owning the property well in advance, but did not occupy it in time for last year's exemption, so they do meet the standard for occupying it prior to the April 1st, and they are recommended for approval for the educational exemption. So we recommend to approve and deny these exemptions as per the list presented.
Okay, thank you. Attorney Leonard, should we approve and deny these individually by group, or can we do the whole page sort of?
I think that as long as it's reflected in the minutes so that you can track which one it is, you can approve it either way, if that makes sense. So either attaching the list or listing it out. I was just actually making a note of that on some of the minutes.
Yeah.
Either way, as long as it's...
I guess we would have to mention them in the minutes. It'll be in the minutes. So can I get a motion to approve the religious exemptions for the properties at 6 Harvard Street, 97 Farley Road, and the partial exemption for 48 Palm Street?
So moved.
Second?
All those in favor say aye.
Aye.
Aye. Opposed, nay. The ayes carry. The next group is the charitable exemptions. Can I get a motion to approve the charitable exemptions for the properties at 2 La France Ave, 121 to 127 West Pearl Street, 2 Shattuck, and finally 2 Shattuck Street?
So moved.
Second?
All those in favor say aye.
Aye.
Opposed, nay. The ayes have it. Next, can I get a motion to approve the educational exemption with a recommendation of approval for 9 Townsend West?
So moved.
Second?
All those in favor say aye.
Aye.
Aye. Opposed, nay. The ayes have it. Finally, can I get a motion to deny the charitable exemption for the properties at 151 Tolles Street and 16 Broad Street?
So moved.
Second?
All those in favor say aye. Aye. Opposed, nay. The ayes have it. Okay. Anything else, Jessica?
Yes.
Administrative?
We have 2 administrative abatements. If you go after all your property record cards there. So we have the tax collector is requesting administrative abatements for 2. These are city-owned properties, so the actual account and the address is owned by the city, but these are bills that are sent out individually because a portion of the building or of the property is leased by someone who pays the taxes on that portion. So these 2 city-owned lease parcels are delinquent with their taxes, but they're also no longer tenants, so these are considered to be uncollectible taxes. The descriptions are here in the details, one of which was Headshots Photography, who's since been evicted, so they're asking that the 2023 taxes are abated for that Headshots leased property. And the other is part of a cell tower on 10 Whipple Street, so they're asking for, what happened was Sprint merged with T-Mobile, and so the Sprint portion of on the cell tower, they have various arrays, And the Sprint portions were removed, but we've continued to tax beyond the time, so the equipment was not there. So the Sprint has not paid, so they're asking for the 2022 and 2023 taxes for the Sprint to be abated, to remove these uncollectible taxes from their books.
Wouldn't T-Mobile be responsible?
I don't know.
That's wild.
Yeah, I was going to ask if.
The email I got at one point, maybe with last winter, was that they had merged, but and so the Sprint equipment had been actually removed, so they were not paying on that portion. T-Mobile is still paying their portions, I believe.
I think we'd have to look at the lease with the city,
Right.
the cell tower leases. I haven't looked at them in forever, but we'd have to look. You would assume so.
Yeah.
The issue here being normally, of course, to enforce the city's right for payment, we put a lien on the property, but that would be ineffectual in this regard, since it's city property already. So we'd have to look to the contract to see what, if any, security was placed there.
That's a tax collector's issue, not ours, though.
Well, if it's abated, it becomes a non-issue because there's nothing to collect. So I thought the inquiry was, would it be T-Mobile's responsibility? And the answer is, it depends. We'd have to look at the contract. I mean, we're
And I
talking
believe
$5,000 here, so, at the end of the day, there's a determination, too, about whether or not the staff time and effort to go into trying to collect the $5,000 is worth it, because we can't follow the normal statutory of putting a lien on this. We're not going to put a lien on the city's, I wouldn't recommend it, anyway, putting a lien on the city's own property.
Any other questions?
So if we abate this, tax collector has no ability to go after it.
Correct, because it's been abated, so there's nothing to collect on.
Is it worth abating it? Why bother abating it? Just so they can clear their screens?
That appears to be the request. I wasn't
Yeah.
involved with it, but that's what it states. Yeah, they consider it uncollectible, which through the normal tax process it is, but it doesn't mean that there wouldn't be a contract avenue. That's just, we haven't
Well,
been.
we'd lose the contract avenue if we abate it, because it would then no longer exist.
I think I heard you, but I'm sorry, there was noise out.
Sure. It would no longer be a contract issue if we abated it, because the debt would no longer exist.
That's a position I would take. I mean, it's certainly a lot easier to point at something and say it's still on the books, right? I mean, we
Yeah.
could argue around that, but I'd prefer not to if this was something we
So-
wanted to do.
Yeah, but that would be the argument you would take if you were representing Sprint. But if you're representing the city, why would we walk away from this $5,000 from a AAA-rated company?
The answer is, I'd have to read the contract.
Yeah.
If the contract is devoid of any mechanism to get security or otherwise, or else we just go to small claims court here. I mean, there is, there's sort of $5,000 worth of staff time to
Yeah.
collect $5,000, I think, because unless there's something else in the contract, I wouldn't even bring this to Superior Court, or I might have to, because it's land, so, it's not a significant amount normally for the city of $5,000, but, that's something, if we want to look at the contract and see if there's anything specific to it, we're happy to do that. I just haven't.
I would prefer that we do it. I mean, we had a guy come in for the veterans exemption, that, he had to come in, and we were going to deny him for $500, and here we're letting $5,000 go. So let's take a look at the contract.
Yeah, sure, we can do that.
And besides that, we have to assume they'll pay our legal fees.
Depends what's in the contract.
Yeah, exactly.
Yeah, so, we'll just have to see. And by contract, I mean the lease. I don't,
Yeah, I guess I'd be comfortable deferring that one, but for headshots, it feels as
Yeah.
though,
Yeah.
yeah.
Could we assume, though, that some effort has been made on, as far as the Sprint T-Mobile one, or is it just automatically goes to an abatement?
I think it's been being worked on for 2 years now. They haven't paid over many years, and after, I believe the tax collector is ongoingly trying to get payment from them. I don't know if Sprint has actually dissolved. It seems like, well, they've merged
Right.
or something, so, but yes, I don't know if that means, like you say, read the contract. Does T-Mobile now?
Let's just read the
Foot
contract
that
and
bill.
see what we can get out of these guys. And what if it's a 10-year contract and they're not going to pay for the next 10 years? Now we're looking at a lot more than $5,000.
Well, they're gone. Well, it seems like they're now gone.
No, but they never go away.
Yeah.
Corporations don't die. Their assets and liabilities went to T-Mobile.
Yeah.
So, I mean, and if all their liabilities didn't go to T-Mobile, they went to a bad asset LLC or something, again, it's $5,000 and change, it's worth I would recommend a look. I'm not saying we're going to recommend,
Yeah, but
just
let's
be
see
our
the contract.
recommendation, but let's just have a look at what the lease says. And, yeah, I mean, the idea that someone can just sort of remove their equipment and say, we're done, that should only be allowed if the lease says the minute you remove your equipment. Because then you get into, well, but there's no infrastructure to tax, but we're not taxing under that, we're taxing under a different statute, so, anyway.
Yeah, they
Couple
made
of
a lot of
different-
money on that cell tower,
Oh, yeah,
you know?
city
Right.
does, we do pretty well on our leases, too.
Good for us, we're supposed to.
Can I get a motion then to approve the administrative abatement for the property at 6 Main Street?
So moved?
Second?
All those in favor say aye.
Aye.
Opposed, nay. Can I get a motion to table the administrative abatement for 10 Whipple Street?
So moved?
Second?
All those in favor say aye.
Aye.
Opposed, nay. The ayes have it. Okay. I believe that's all we have. Administrative. Public comment. I don't see anybody here. Comments by members of the board. Anything?
I got something I want to talk about, maybe we'll do it in closed session in addition.
Okay. In that case, let's go to non-public. Can I get a motion to go into non-public for 2 reasons? First, to discuss matters which, if discussed in public, would likely affect adversely the reputation of any person other than a member of this board, unless such person requests an open meeting. This exemption shall extend to include any application for assistance or tax abatement or waiver of a fine, fee, or other levy, if based on inability to pay or poverty of the applicant pursuant to RSA Section 91-A:3, Roman numeral 2, parentheses C. Second, under 91-A:3, Roman numeral 2, parenthetical L, for the consideration of legal advice provided by legal counsel either in writing or orally to one or more members of the public body, even where legal counsel is not present.
So moved?
Second?
All right, by roll call, Jay Mancara,
Aye.
Charles Dobbins.
Aye.
Robert Early, aye. We are now in non-public session at 9:38.